Witchcraft in Russia and Ukraine, 1000 to 1900, a Sourcebook. Edited by Valerie A. Kivelson and Christine D. Worobec. Chapter 3. The Prosecution of Witchcraft. Witchcraft Trials and the Law in the Ukrainian Lands. The very earliest statutes on witchcraft from the Rus territories, recorded in the Statute of St. Prince Volodymyr on church courts, and the Church Statute of Yaroslav the Wise, designate witchcraft as a religious infraction to be adjudicated in church courts. When we pick up the thread again in the early modern period, however, the crime of witchcraft had come to be considered more a secular crime, to be heard in secular, sometimes criminal courts in the Ukrainian towns of the Polish-Lithuanian Commonwealth. Trials generally focused on the kinds of real-world harm that witches were thought to inflict, including loss or damage of property or livestock, as well as sickness, impotence, infertility, or death. Acting on complaints from victims of alleged witchcraft and sorcery, magistrates of the autonomous Ukrainian towns and cities investigated them, identified and summoned witnesses, and applied torture if they thought it was necessary. Multiple legal frameworks operated simultaneously in the Ukrainian lands. In the 15th and early 16th centuries, the Ruthenian lands, that is, Eastern Orthodox areas under Lithuanian rule, were governed loosely by some adapted form of the Ruskaya Pravda, the medieval Rus law code and customary law. Perhaps because witchcraft had been categorized as a religious infraction in medieval times, the secular Ruskaya Pravda made no mention of the subject. The Pravda was superseded in the Grand Duchy of Lithuania and its Ukrainian territories by the new Lithuanian Statute of 1529, which in turn was reissued in two subsequent iterations in 1566 and 1588. For Ukraine, however, it was the second version that in principle remained most relevant, because in 1569, as part of a negotiated union between the Kingdom of Poland and the Grand Duchy of Lithuania, the Ukrainian regions passed into Polish control. In the period of the witch trials, Ukraine answered to first Polish, then Cossack, and ultimately to Russian rulers, not Lithuanians. Nonetheless, and just to make matters more confusing, officially, the 16th century Lithuanian statutes functioned in Ukrainian lands before and during the period of unified Polish-Lithuanian rule, and continued to apply in the region long after it was incorporated into the Russian Empire. Each of the three sequential versions of this code addressed the matter of witchcraft or sorcery, each time with greater specificity. The first statute of Lithuania of 1529 explicitly mentioned witchcraft and its ability, presumably by way of spells, to neutralize the torture of criminals. The second statute of Lithuania of 1566 identified where such spells could be found: in the mouth, hair, and armpits of the accused, in the same places where spells were searched for during witches' trials in Western Europe. There was no direct punishment for the use of spells as such. However, a person suspected of using spells during torture was immediately considered guilty. The third Statute of Lithuania of 1588 repeated the same provisions regarding spells, but added witchcraft to a list of criminal acts. In keeping with the fluid practices already noted, the statutes functioned at the same time and often on par with other legislation, and the courts could flexibly select which norm to invoke. The historian Katerina Dissa finds little mention of the statute's precepts in Ukrainian witchcraft trials. We come across very occasional references, including one invocation of a non-existent article of the 1588 statute, but by and large, it was Magdeburg Law and the Carolina that set the framework in which witchcraft was discussed and prosecuted. Magdeburg Law, a set of Germanic laws that conferred considerable judicial and administrative autonomy on town authorities, had been gradually imported to significant towns in the Ukrainian lands of Galicia-Volhynia in the 14th and 15th centuries. Magdeburg Law allowed municipalities a degree of protection from royal or princely incursion. As towns grew in prominence from the 15th through the 17th centuries, Magdeburg rights were extended to them by Lithuanian princes, Polish kings, and Ukrainian hetmans. In the aftermath of imposing the unpopular Union of Brest in 1596, which mandated that Orthodox believers recognize the authority of the Pope in Rome in exchange for keeping their Byzantine Rite rituals, Polish authorities extended Magdeburg rights to the remaining townspeople and Cossacks of the eastern regions, or what became known as Right Bank Ukraine. For the most part, magistrates in the Ukrainian lands followed the legal recommendations that Bartolomé Graitsky collected in various compendia. A 16th century jurist from Krakow, Graitsky not only selected articles from such Germanic legal codes as the medieval Speculum Saxonum and its popular variants, which were referred to as Magdeburg Law and Chelmo Law, and the Code Carolina, but also translated them from Latin into Polish and provided commentaries. According to Dissa, judges most frequently cited two of Graitsky's compilations. These guidelines, as taken from the royal laws with Charles V the King, ordered published in all his domains, first published in 1559, and procedures for the courts and affairs of towns under Magdeburg Law in the Polish Commonwealth, published the same year, a decade prior to the creation of the Polish-Lithuanian Commonwealth through the union of the Polish monarchy and the Lithuanian Grand Duchy. Graitsky's influential guidelines were based on the Code Carolina, but creatively adapted its legal norms to conform to Polish reality. For example, Graitsky provided commentary on the section about judicial torture, expressing several concerns and offering cautionary advice to judges. He worried that fear would induce innocent defendants to make false confessions, even though he believed in the necessity of torture. Guidelines was the most heavily used of Graitsky's manuals because it included descriptions of the various types of courts, their functions, the roles of the participants in the process, and finally, the death penalties for various crimes. Each town and city court was supposed to have one copy of these guidelines. Some of them turned out to be handwritten copies. The manual's prescriptions were cited frequently, if not always accurately, in court cases. Graitsky cites witchcraft under 4 separate sections in his guidelines. It first appears under a heading that establishes the circumstances under which a person should be tried for witchcraft. These included the teaching of witchcraft, threatening the others with witchcraft, and the actual use of witchcraft. Moving beyond the Carolina, which preserved intact the Roman legal distinction between harmful and harmless magic, Graitsky appears to imply that all witchcraft was malevolent in nature. Merely a suspicion that witchcraft had been employed, according to the guidelines, was enough for an accusation of witchcraft. Veritable harm was not a necessary element. In practice, accusations came from private citizens, not from state representatives. They flowed into courts from society rather than being part of a top-down witch hunt. Furthermore, Graitsky deemed any hint of witchcraft, quote, inappropriate for Christians, unquote, an act against God, and, quote, forbidden by law, unquote. Nevertheless, direct references to pacts with the devil's mark, the coven of witches, the witches' Sabbath, and apostasy that were so popular in the Germanic lands, but not in the Polish-Lithuanian Commonwealth, were conspicuously absent in Graitsky's reworking as they were in the Carolina. Magdeburg Law continued to govern Ukrainian towns even after areas of Ukraine broke away from the Polish-Lithuanian Commonwealth in the mid-17th century. Document 3.2. These guidelines are taken from the royal laws which King Charles V ordered published in all his domains, 1559, by Bartolome Grajicki. Article 14. Evidence against witches and all those who occupy themselves with witchcraft and sorcery. When it is claimed that someone wants to teach others such things, i.e. witchcraft, or that someone threatens to use witchcraft against another person, and something befalls the threatened individual, or that someone is suspected of it on the basis of words, gestures, behavior, and other deeds peculiar to such people, and are used by such people for which they become notorious, such a person ought to be accused, and on the basis of such signs may be condemned to torture, since all such knowledge is against the Lord God, and it is inappropriate for Christians to occupy themselves with it. It is forbidden by law and severely punished. Article 22. When one confesses to committing sorcery or witchcraft during torture, he has to be asked about the reasons, conditions, and circumstances for using the above-mentioned sorcery or witchcraft. Also, which implements were used, in what manner, and at what time, or what words were said, and what was done. In the event that he says that the charms or other similar things are hidden somewhere or buried in the ground, an interrogation must be initiated, and one has to search thoroughly to be sure that such things can be found. If these objects are found, the sorcerer has to be asked which words he uttered and how he used them. Accordingly, the person also has to be asked who taught him such things, in what way did he acquire this knowledge, how many times, against whom was it used, or what harm was done to another. Document 3.3. Procedures for the courts and affairs of towns under Magdeburg Law under the Polish Crown, 1559, by Bartolome Grajicki. About various manners of execution for various criminals. The following executions for criminals are mentioned in Speculum Saxonum, Book 2, Article 13.16.36 in particular. Thieves are to be hanged. Traitors, robbers, looters are to be broken on the wheel. Murderers, rapists of virgins, and those who were apprehended during the act of adultery must be beheaded. The abjurer of the Christian faith must be burned. Witches and the individuals who supply poison should die similarly. About various tortures. Also, sometimes when one is to be tortured, he should first have all of his hair shaved in order to discover if he has some elaborate objects connected to sorcery or some witchcraft which can prevent him from feeling any pain.